Good afternoon, and thank you for joining us today. My name is Maria Swaby, and I'm the GSA Procurement Ombudsman and Industry Liaison. As a preliminary matter, I wanted to make sure everyone is aware that today's meeting is being recorded. The PowerPoint slides and the recording of this session will be posted on the Section 889 webpage at acquisition.gov at a later date. The posting on acquisition.gov will take some time to ensure Section 508 compliance. Therefore, the slides will also be shared via email to all the webinar registrants at the conclusion of this webinar. First, let me thank you for submitting your questions in advance. They were informative in preparing for this session. Please note that we cannot address all the questions sent in during today's session. I also wanted to let you know upfront that this webinar will focus on GSA's implementation of the FAR rule and not on the FAR rule itself. GSA does not have answers to questions asking for definitions of certain terms such as use and subsidiaries and affiliates, nor does GSA have a list of such subsidiaries and affiliates. Answers to these questions are not addressed in the FAR rule. However, we do encourage you to submit comments to the FAR rule regarding those questions before the September 14th deadline. A list of some of these questions is included in the slides we will send out. Now, I'd like to take a moment to set the stage for what this webinar will cover. This webinar assumes some familiarity with the Section 889 FAR rule and what it requires. Therefore, today's session will focus on certain aspects of GSA's implementation of Section 889. GSA cannot speak to other departments or agencies and how they may implement Section 889. Now on to the format of the webinar. In a few moments, Michael Thompson, Senior Policy Advisor in GSA's Acquisition Policy Division and our resident Section 889 Policy Expert, will deliver a presentation addressing some aspects of GSA's Section 889 policy implementation. Next, we will have some introductory remarks from our panel of GSA business line leaders. Then Michael will moderate the Q&A session with the panels, and I will come back and close us out. A final note, we will not be addressing questions and comments sent in the chat and Q&A functions of this session. Michael, the floor is yours.
Thank you, Maria, and good afternoon, everyone. Thank you for joining us. I'm going to be sharing my screen, so give me a moment to get that set up to share my slides with you all. All right, hopefully that's looking okay. As Maria said, I'm going to walk through Section 889, but first just let me introduce myself. My name is Michael Thompson. I work for GSA Senior Procurement Executive, and as Maria said, thank you for the introduction. I've been working on Section 889 for GSA. I'm excited to have all of you here talk about some of the stuff since the last time we were together. If you have already looked at the webinar that we gave in partnership with GSA's Office of Small Disadvantaged Business Utilization. So this will be some of the updates since then. And then happy to have a bunch of GSA business line leaders on the line as well to answer some questions that we'll get to after the slide presentation. So as I hope everyone is aware, Section 889 includes two prohibitions. The first prohibition, Part A, is what we call it, was effective last August 13th, and it says the government may not obtain, either through a contract or other instrument, certain telecommunications equipment or services produced by 5 named Chinese companies or their subsidiaries and affiliates. And then Part B went into effect this August, so just under a month ago. The government may not contract with an entity that uses telecommunications equipment or services, I should say certain telecommunications equipment or services as a substantial or essential component of any system or as critical technology as part of any system produced by any of the same 5 named Chinese companies or their subsidiaries and affiliates. And from the most recently effective FAR rule, it was defined that use under Part B is regardless of whether that use is in performance of a federal contract. So real quickly, the differences between Part A and Part B are as follows. First, Part A has to do with what the government can do. The government may not obtain covered telecom. So the government can't buy it. It also can't enter into a grant to receive it. It can't get it for free. The government cannot obtain covered telecom. Then Part B, that applies to contracts only and contractors only. And it says that contractors cannot use covered telecom. So the government, the way the FAR rule implements this, which we'll get into in a moment, the government cannot extend or renew a contract with an entity that uses covered telecom. And again, that use is regardless of if it is in performance of a federal contract or not. So Part A really, because it only applies to what the government can obtain, it really only affects IT contractors, right? Because if you are, let's say, a furniture company that sells furniture to the government, you're not providing IT to the government, so you're not providing covered telecoms to the government, so that's easy. However, Part B applies to any IT that any company that wants to be a government contractor uses. So it really applies to every sector. No matter what a company makes or sells, all equipment, systems, and services used by a company that is or wants to be a federal contractor must be checked for covered telecommunications equipment and services. So there's three elements in the FAR rule that we're going to talk about very briefly. Again, this is a more high-level discussion than ones we've had previously. The representation provision, the SAM representation provision, and the reporting clause. So starting with the representation provision. This is at FAR 52.204-24, and it requires representations regardless of whether the offeror believes that an exception under paragraph B of the representation provision applies. So it requires offerors to represent whether they provide covered telecom and whether they use covered telecom. Again, regardless of if they think an exception applies. Whether or not the exception applies, the offeror can provide that information along with the representation, but that's up to the government to adjudicate and decide. Offerors are required to ensure that their representations requiring equipment and services provided to the government and their representations regarding equipment, systems, and services used by the offeror are accurate, and as such, offerors may want to consult with their own legal counsel. Understanding the additional information that's required by paragraph E of the representation provision may be helpful in determining the appropriate level of investigation required before making representations. That said, I'm going to talk a little bit more about offeror due diligence. So as we know, per the FAR rule, the representation about use is based on a reasonable inquiry. And the reasonable inquiry is basically information that's already in the offeror's possession. So offerors should conduct reasonable inquiries and then represent their findings to the government via the representation clause regarding all equipment, systems, and services used by the offeror. That's regardless of the geographic location of the equipment, system, or service, regardless of the geographic location of the use. And this may include equipment, systems, and services owned or provided by other companies if they're used by the offeror itself. Those other companies might be affiliates, parents, subsidiaries, subcontractors, or suppliers. Now we know, per the FAR rule, that the representation is limited to use by the offer itself. The representation does not concern use by other legal entities, including those I just mentioned. However, as mentioned in that previous bullet, it does concern use by the offeror of equipment, systems, and services that are owned or provided to the offeror by other companies. So we've talked about this before. The representation provision does not flow down to subcontractors. And we just mentioned that the representation is limited to use by the offeror itself. That said, it's not limited to use by the offeror of equipment, systems, and services owned by the offeror. It could be, or it does include, use of any equipment, system, or service that's used by the offeror, regardless of who owns it, regardless of who provides it. So you may need to look into, per your reasonable inquiry, equipment, systems, or services owned by other parties if they're used by the offeror. We're going to talk about the reporting clause next and then the SAM representation provision. So the reporting clause, as we know, requires contractors and subcontractors to notify the government if they identify that covered telecom are used as a substantial or essential component of any system or as critical technology as part of any system during contract performance. So some important elements there. One, that exception in paragraph B of the representation provision, about which I said you have to represent even if you think it applies. Under the reporting clause, the contractor is allowed to make that determination on their own. So the representation provision, you have to represent whether or not you use any covered telecom. But under the reporting clause, you only have to report if you use covered telecom as a substantial or essential component or as critical technology. So that exception does apply, is allowed to be used pre-disclosure to the government under the reporting clause, as opposed to it can't be used pre-disclosure in the representation provision. The second thing is their use here is limited to during contract performance, as opposed to, again, what might be a broader interpretation of uses regardless of whether it's in support of federal contract performance under the representation provision. Another key difference is that unlike in the representation provision's requirements, the reporting clause does flow down to subcontractors. And lastly, it's important to note the reporting clause is only about reporting, not representation. There are no representations reporting required by the reporting clause. What the reporting clause requires is this report mentioned in the first bullet. And the last provision is the annual SAM representation provision at 52.204-26. A fourth interim rule was published on August 27th and will be effective along with the technological update to SAM.gov on October 26th. That's all of this year. This fourth rule updates the SAM representation provision, which already includes the requirement to represent whether an entity at the SAM level provides covered telecom to the government, and now will also require entities to represent in SAM whether they use covered telecommunication equipment or services. And the purpose of this here, because those are exactly the same questions in the -24 representation provision that's included in all solicitations, right? So why do we do this? The purpose is that starting October 26, once SAM's updated and this FAR rule goes into effect, if an entity represents in SAM that it does not provide and does not use covered telecom, it will only need to re-represent annually via SAM. It does not respond to that representation provision when that entity submits offers. So that's where we are in the FAR in terms of the representation provision, the reporting clause, and the annual SAM representation provision. We're going to talk now about some GSA-specific implementation of these requirements. First, the Federal Acquisition Service. Existing fast indefinite delivery vehicles are being modified to incorporate the updated reporting clause in accordance with the FAR rule. Mass modifications began to be issued on August 13th, the day the FAR rule went into effect, for schedule contracts and for certain non-schedule indefinite delivery vehicle contracts. All other IDV contracts are being modified manually. Information about whether an IDV has been modified may be found using the GSA FAST Section 889 Part B Contract Vehicle Modification Tracking Dashboard. You can see that's a hyperlink here. Once you have the slides, you'll be able to click through the hyperlink. For anyone who wants to try to find it now, it's on d2d.gsa.gov. Note additionally that information is also available on Contracts Online for schedules and on program websites. Now the Public Building Service is also updating its existing indefinite delivery vehicles to include the updated reporting clause in accordance with the FAR. And the way they're doing it is via robotic process automation, also known as RPA or ABOT. Additionally, as Section 889 concerns the Public Building Service, hopefully you are aware, if you're in this industry sector, that GSA has also deemed that the Section 889 representation and reporting requirements also apply to GSA's real property lease acquisitions. As such, GSA has also issued a leasing alert, LA 20-11, to discussing how Section 889 applies to GSA's lease acquisitions and also how GSA lease contracting officers should proceed. Again, that's a hyperlink there. You'll be able to click through that once these slides are shared. So we've talked about the FAR, we've talked about GSA-specific implementation. Now we're going to talk about waivers. There are two types of waivers that are contemplated in Section 889. The first is a waiver granted by the Director of National Intelligence. And Section 889 says the Director of National Intelligence may provide a waiver to either Section 889 provision for national security interests. Additionally, there is the ability for agency heads to waive the prohibitions in Section 889. Agency heads may, on a one-time basis, delay the effect of Part A through August 13th, 2021, so not even for a full year at this point, and may, on a one-time basis, delay the effect of Part B through August 13th, 2022, so just under 2 years from today. As we talked about before, that requirement and some additional requirements on the agency waiver process really make it more of a delayed implementation and not a true waiver like that can be granted by the Director of National Intelligence. However, the bar for both these waivers is very high. National security interests, obviously very high. And as you'll see on the next slide, the requirements for agency granted waivers are also very high. So as we've talked about in previous discussions about Section 889, and as you can see in Section 889 itself and in the FAR rule, each agency granted waiver must include a compelling justification for the additional time needed, a full and complete laydown of and a phase-out plan to eliminate the covered telecom from the offeror or contractor systems, an ODNI determination that granting the waiver will not adversely affect U.S. national security, and 50-day advance notification to the FASC and to the Office of the Director of National Intelligence. Additionally, agencies must notify Congress within 30 days of issuance of a waiver. So the ODNI waivers have to be for national security interest, and agency granted waivers have to have all of this information and can only last up through August 13th, 2022, so less than 2 years from now. So we've said at GSA that waivers should only be sought as a last resort, and there are only two circumstances in which a GSA contracting officer may pursue a waiver. One, for a new procurement, when there is no other means to make an award in time to avoid government mission failure, and two, for an existing contract or an existing existing order, where there is no other means to replace the contractor in time to avoid government mission failure. Those are the only times where GSA is going to even contemplate granting a waiver. GSA's acquisition letter, MV 20-10, again, this is a hyperlink, but it is available on acquisition.gov, includes a multi-step process for GSA contracting officers to follow when pursuing waivers. Now, although the acquisition letter is addressed to GSA's acquisition workforce, and this waiver process is as well, it may be educational for industry to look at that waiver process to really see all of the steps that are in place that have to go through before a waiver can even be granted. And it can really illuminate just how rare I believe that waivers are going to be granted. Now, Maria mentioned that there are some questions, still some outstanding questions. And those are questions that aren't addressed in the FAR rule, and GSA, frankly, doesn't have answers to them right now. And so if you have suggested answers, or if you think an answer to a question is particularly important for your industry, or if you have answers to any of the other questions that are in the FAR, request that you provide comment to the FAR rule. Comments to the third interim FAR rule are due September 14th, which I believe is Monday or Tuesday of this coming week. And then comments to the fourth interim FAR rule are due October 26th. Comments may be submitted at regulations.gov, search for FAR case 2019-009. This is for the third interim FAR rule. For the fourth interim FAR rule, search for that FAR case number. Select the corresponding comment now link and follow the instructions provided. Of course, once processed, all comments will be publicly viewable on regulations.gov, and comments may be submitted anonymously, which doesn't mean that they won't be addressed or won't be published. It just means that identifying information will not be gathered. So again, request that you do provide comments, because the more information we get from industry, the better the FAR Council can do at making this rule work for everyone. I'm going to skip through just to a couple more slides because we have a few more minutes. I want to when you get this slide presentation, there'll be some slides at the end. The first is publicly available resources on acquisition.gov. Again, these are all hyperlinks, but there's the text of all 4 FAR rules. video and slides from the OSDBU webinar I mentioned previously, a 2-page industry flyer, the GSA acquisition letter we spoke about, the GSA class deviation that extends the Section 889 FAR representation and reporting requirements to GSA's real property lease acquisitions and commercial solution opening procurements, an addendum to GSA's previous class deviation, which canceled the GSAR representation clause and suspends the rest of the previous deviations guidance. Also links to GSA's SCRIM Review Board's decision rubrics for Parts A and Parts B. And coming soon to acquisition.gov, we have frequently asked questions, implementation tables, and decision trees. As soon as those are available, they will be posted on that same website. Additionally, these are some resources we mentioned earlier in the slide deck, but I wanted to have them all on 2 slides at the end of the presentation. The leasing alert is available via that link, as are the tracking dashboard and contracts online for information about when FAST IDVs have been modified. And lastly, there are a bunch of outstanding questions. These are some of my favorites that we don't have answers to right now. Maria mentioned a lot of those again, and I'm going to scroll back now. All of those questions, we'd like you to, if you have answers to those, if you have suggested responses, if you have reasons why those answers are particularly important for your industry or your business, please include all that in your comments, because again, the more information you can get to the FAR Council, the better that final rule is going to be.